Good morning. This is John Viola, Thompson Coburn in Los Angeles, and welcome to our first webinar of the year on California employment laws, what you need to know. Just some background on myself. I just joined Thompson Coburn in January. I'm a New Yorker, moved to California in the late 80s. I've been doing labor and employment law for various clients in the insurance, health, retail, and manufacturing industries for over 35 years. So right now my practice encompasses traditional employment law, not union stuff, but employment law, class actions, wage and hour claims, discrimination, harassment, wrongful termination, whistleblowers, disability, etc. So with that in mind, let's get right to it. I know a lot of you are probably on the lunch hour in the Midwest or even on the East Coast. Hopefully this is not going to upset your appetite for whatever you're doing right now. So let's go to it. Let's start out with the new laws in 2015 in California. You know, we like to think of California as the land of fruits and nuts, and this is, after all, a very employee-friendly state. So we're starting with the sick leave law, which is effective July 1st, 2015, but in defense of my adopted state, we are not the first jurisdiction to have a sick leave law. New York City has a sick leave law, as does Massachusetts, Connecticut, Philadelphia, the District of Columbia, San Francisco, Oakland, and of course that gigantic urban center, Passaic, New Jersey. And as you may have heard in the State of the Union address, President Obama is thinking of implementing a national sick leave law. But anyway, California's sick leave law, which is effective July 1st, 2015, requires virtually all employers to provide workers with a minimum of 3 paid days of sick leave per year. And this law applies to all California employers regardless of their size. There's no minimum requirement for a number of employees, and there's no exemption for small employers. Even if you only have 1 employee, the new sick leave law applies. And even though the law is not effective until July 1st, 2015, you should have begun posting on January 1st, 2015 in a conspicuous place a poster explaining the new law. And the Labor Commissioner, of course, has a revised notice to employees which provides the rights of employees under the sick leave law. So if you haven't done so, please get that poster up now. So the way this law works, although there's a lot of questions on the law, there are no regulations yet, etc., all full and part-time California employees who work for 30 or more days in a year are eligible to receive these 3 days of sick pay. You have the option of implementing workplace policies limiting accrual and year-to-year carryover of sick leave, however. Every 30 hours work, an employee will earn 1 hour of paid sick leave, and you have 2 options by which to provide sick leave: the accrual method or the lump sum method. Under the accrual method, employees can earn sick leave at a rate of 1 hour for every 30 hours worked, and this includes, importantly, not only regular hours, but overtime hours. You can allow sick leave to run over to the next year, but you don't have to require an employee to accrue a total of paid sick leave in excess of 6 days or 48 hours. Now, if you prefer not to deal with this accrual method, you can use a lump sum method, where you would just give an employee 3 days or 24 hours of paid sick leave at the beginning of the year, and you can let the employee take their sick leave anytime they want to during the year. Now, importantly, and we'll get to all the requirements on the California wage statement as we proceed with the program, but employers need to notify employees every single pay period of their paid sick leave balances, and you have to track separately their sick leave accrual and use. You can either put this on the wage statement or in a separate writing that's provided at the same time as the wage statement. Now, unlike with vacation time that you may allow to accrue, or which is considered a wage under California law, Sick pay is not considered a wage, so you have no requirement of compensating employees who are terminated for their unused accrued sick leave. And you don't have to provide additional PTO if your existing policy allows use of that leave for all of the same purposes as the sick leave law provides, and the policy either satisfies the accrual, carryover, and use requirements, or your PTO policy provides no less than 3 days of paid sick leave or equivalent paid leave time off for each year of employment. And unfortunately, this law is rather new. It's not even in effect yet, so we don't know whether or not as an employer you can request documentation that sick time has really been used for sick time. Okay, let's move on to what else is new in California for 2015. The minimum wage in California is $9 an hour, but it's going up next year to $10 an hour. And there are cities in California with higher minimum wage requirements, believe it or not. San Francisco is up to $10.74, and San Jose is at $10.15, although there is a bill, I must warn you, to raise the minimum wage even further in California. Also new for 2015 is harassment training. As you probably know, we right now require employers with more than 50 employees to provide 2 hours of training every 2 years for supervisors who are located in California. Beginning January 1st of this year, you also need to include anti-bullying training. Now, there's no anti-bullying law. However, you still need to include anti-bullying training with harassment training. And what is bullying? It's really not defined, of course, but we've seen some indication from some courts that bullying is considered abusive conduct which serves no legitimate business purpose. Okay, moving on to what is a pretty big issue in California and has been for a number of years, arbitration agreements. We had a decision in 2014 which the U.S. Supreme Court denied cert in 2015 in the Iskanian versus CLS transportation case. And in that case, and this was really good news for employers, the California Supreme Court held that an express class action waiver in an employment arbitration agreement is enforceable under California law. The bad news from that decision, however, is that the Supreme Court held that you cannot, in an arbitration agreement, require an employee to give up the right to bring a PAGA claim, because this was contrary to public policy. So where does that leave California employers with respect to arbitration agreements? You can now require employees to sign an arbitration agreement which expressly limits the employee to bringing his or her own individual claims in arbitration, which prevents the filing of a class action in court. There is some new news on this front. On May 5th, the California Supreme Court is going to hear oral argument in the case of Sanchez versus Valencia Holding Company. Now, that case is not an employment case, but it has important implications in the employment area. In that case, a California car dealer sought review after the California Court of Appeal found that the company's arbitration provision with a class action waiver contained one-sided terms that favored the company to the detriment of the buyer, and therefore was not enforceable under the California Supreme Court's decision in Armendariz. And on May 5th, the California Supreme Court is going to hear oral argument to determine whether the United States Supreme Court's decisions in ATT Mobility bars California standards in validating mandatory arbitration provisions in consumer contracts as procedurally and substantively unconscionable. So while this case involves a car sales contract with a customer, it also could affect employment arbitration agreements, particularly with respect to current requirements under California law as to procedural and substantive unconscionability, and whether they are preempted and barred by the Federal Arbitration Act. So we'll have to see what happens in this case, the Sanchez case, given that in an Iskanian, the U.S. Supreme Court denied cert, and we're still left with you cannot waive a PAGA claim, at least in state court, because the federal courts in California have rejected the Iskanian court's holding barring arbitration of PAGA claims. And you can see I list some of these holdings here. Okay, also new in 2015 is the expansion of the joint employer liability concept in California. Under California Labor Code Section 2810, employers who have provided workers from labor contractors, such as employment agencies or temp agencies, are now subject to potential liability for wage and hour and other violations committed by the labor contractor. You're exempt if you have less than 25 employees or you hire fewer than 5 employees from labor contractors. Also new in 2015 is the immigration issue dealing with driver's licenses. As you probably know, since 2013, California has allowed undocumented immigrants to apply for driver's licenses, and the DMV began issuing these licenses on January 1st of this year. Importantly, you can't use a driver's license to establish eligibility to work, even though it may state that federal limits apply. And it's also illegal to discriminate against employees who present the licenses for employment purposes. You need to keep this information on the driver's license private and confidential. Also new in 2015 is the protection for victims of crime or domestic violence under Labor Code Section 2030 sub C. An employer may not discharge or in any manner discriminate or retaliate against an employee who's a victim of domestic violence or a victim of sexual assault for taking off time from work to obtain relief or to help ensure his or her health, safety, or welfare or that of his or her children. An employee who's a victim of domestic violence or a victim of sexual assault may take time off also to seek medical attention, psychological attention, etc., or to attend judicial proceedings related to the crime. Next, what's new for 2015 is the extension of the Fair Employment and Housing Act anti-discrimination and anti-harassment laws to unpaid interns. And this is really important. AB 202, which was just introduced earlier this year in the Assembly, would extend a FEHA to pro sports teams to treat cheerleaders as employees. As we're going to see going through the presentation, this comes out of an actual case. Before we move on to some unique California requirements, I just want to preview for you some new laws that may come up later this year or may be effective in 2016, something that some of these acts the California Chamber of Commerce has labeled job killer bills. So the first one of these is Senate Bill 406. What this does, this bill seeks to expand the number of employers that would need to provide workers with 12 weeks of unpaid leave under the California Family Rights Act to tend to a serious health condition or care for a sick family member. And under this bill, California, as it likes to do, would depart from federal law by cutting the employee threshold down from 50 employees for application of federal law to 5 under California law, and expanding the leave to include not just care for a child, parent, or spouse, but also a grandparent, grandchild, sibling, domestic partner, or an adult child. The second of the job killer bills is Assembly Bill 357. This bill would penalize food and retail companies for changing an hourly employee's work schedule if the employer fails to give at least 2 weeks notice of the change in schedule. And we talked about minimum wages a few minutes ago. Well, SB 3 would raise the minimum wage in California by $3 over the next 2.5 years. And instead of going to $10 an hour in 2016, under SB 3, the minimum wage would go to 11 hours. And considering that employers in California are already upset about $10 an hour, this is met with some shock and a lot of unhappiness by employers. But this bill would raise the minimum wage further to $13 an hour in July of 2017, and then even going beyond that, starting in 2019, would automatically index the minimum wage to inflation on an annual basis. Yet another job killer bill is Assembly Bill 67. This would provide that employees who work on Thanksgiving and Christmas would receive double time, basically applying to the what used to be Black Friday, I guess now we'll call it Black Thursday and Christmas Day shopping events. Finally, I don't know that this is a job killer bill, but AB 1038 would let non-exempt employees opt for a schedule of working 10 hours a day, 4 days a week, without the requirement of overtime, without having to go through California's current pretty complicated and cumbersome approval process, which allows employees to opt to work 10 hours a day, 4 days a week, without the overtime requirement. But let's discuss some of the things that are different under California law for a few minutes. The first one is classification issues. And I want to talk about this for a few minutes because it's so important in the wage and hour field. And the issue, of course, is who's exempt and who's not exempt. And just like under the FLSA, California does have two tests to qualify as exempt. But of course, California likes to go its own way, as the song says, and our tests are different. For instance, under federal law, the salary test is $455 a week, or $23,600 a year. But under California, we are $720 a week, or $37,440 a year, going up in January of 2016 to $800 a week, or $41,600 per year. And of course, because we have to go our own way on everything, the duties test is also different under California law. Under federal law, the employee must be engaged primarily in exempt duties, and there is no absolute percentage requirement. California has its own requirement, however, that the employee must spend at least 50% of his or her time performing exempt duties. What's also unique to California are the 17 wage orders which regulate employee wages, hours, and working conditions. I mean, there's too many of these to go over here, but they can be very specific, applying to agricultural, food industries, of course, the movie industry, which is important in this state, et cetera. But of course, sometimes you may have employees doing more than one job, or your business encompasses several different factors. So you have to determine what the principal purpose of the business is and determine which wage order applies to you. Given that it's lunchtime for some of you, we should probably talk about next California's pretty unique meal and rest period requirements. And these requirements are the source of constant litigation. I just got today a case with 2 employees and a class action dealing with meal and rest periods because the failure to provide the required meal and rest periods leads to a whole host of problems, penalties, and damages, as we'll discuss right now. So under California law, employers must provide mandatory meal periods, unpaid, of 30 minutes. And the employee must get the meal period no later than the end of the employee's 5th hour of work. So if an employee starts at 7 o'clock in the morning, the meal period must start no later than noon. And this is very important under California law. The meal period must be completely uninterrupted. The employer must relieve the employees of all duties and relinquish control over their activities so that they can take an uninterrupted 30-minute meal break. And the employee cannot be required to stay on the premises. The employee must be free to come and go as they please and have a totally uninterrupted meal break. And if your employee is working more than 10 hours, they need to get the second meal break. So how do you police this? Well, you don't have to. Under the California Supreme Court's decision in Brinker versus Superior Court in 2012, employers do not have to make sure that employees take their meal breaks. Once the meal period is provided, there is no duty to police meal breaks to make sure that no work is being done. So you need to make sure as an employer that you have a policy, that employees know about it, put it in your employee handbook, remind them, and make sure they know that the meal break is provided. Because I've had federal judges in class actions say, well, if there's a policy, then there's no problem here, and there really is no basis for class certification. Okay, in addition to meal breaks in California, you also have to provide your employees with rest periods. But unlike with meal breaks, the rest periods are paid. Employers must provide paid rest periods for employees who work at least 3.5 hours a day. The rest periods need to be in the middle of each work period. I mean, it doesn't have to be exactly in the middle, but it should be around the middle of the work period. And the employee gets at least 10 consecutive minutes for each 4-hour period work. Unlike with respect to meal periods, you can require the employee to stay on the premises. You can interrupt the rest period. You probably shouldn't. Sometimes it happens. So what do we do with these meal and rest periods? What should you do to make sure you comply under the Brinker test? Well, you need to relieve all employees of all duties during their meal breaks, at least non-exempt employees, I should say. Make sure your employees accurately record time in for meals and time out. It's probably a good practice to audit time card records to make sure that employees are accurately reporting their time in or out, or if you see a pattern of employees who work through their meal breaks, and this comes up a lot. You'll get employees who are not accurately recording their time, and then down the line they'll claim they worked through lunch and they weren't afforded a meal break because they were playing games with their time cards. Your managers need to know that these requirements of rest and meal breaks are important and must be taken, and that they cannot be taken late. I've got another class action going where people would, clock in early or late for lunch, and of course now we're faced with claims that a full 30-minute wasn't provided because employees were jobbing the system, so to speak, and the managers didn't notice it and were not aware of the importance and implications of what was going on. You should have your employees notify their supervisors or management, or preferably actually someone in HR, if they have been denied their meal or rest breaks. And they should report the reason for any missed meal period to Human Resources. Okay, California, of course, has its own overtime requirements. This is a problem. Many national employers and even California employers don't really know about the requirement for some reason or refuse to believe it. But unlike federal law, California law requires payment of overtime when an employee works more than 8 hours in a day, even if they only work, say, 8.5 hours for that entire week. So under California law, you need to pay overtime if the employee works more than 8 hours a day, and there's also the 40 hours a week requirement. That's there as well. And if the employee works more than 12 hours in a day, you need to pay double time. Of course, it's not easy to lose an employee in California. Why would you make anything easy here? So we also need to be concerned about the last pay. When employees are discharged, in other words, when they're fired, all unpaid and earned wages must be paid at termination. So that means you just can't fire someone on the spot and send them their check later. You need some advance notice, at least internally, to have a check ready with all their unpaid and earned wages, including their accrued but unpaid vacation time. However, if an employee resigns, if you don't have 72 hours notice of the resignation, you have 72 hours to pay the unearned and unpaid wages. If they give you at least 72 hours notice, you need to pay the unpaid wages when the resignation takes place. And as I mentioned, earned and unpaid wages includes vested vacation pay, because vacation pay, even though not required by California law, if you give vacation, it's considered a wage. And once vacation accrues, it can't be forfeited. Now, you can have a vacation cap, but it's got to be a reasonable cap, say 1.5 times the yearly accrual. And vacation in California accrues continuously throughout the year. Okay, I briefly mentioned wage statement requirements. California has very specific wage statement requirements. There's got to be 9 categories of information on an employee's paycheck stub, including gross wages earned, total hours worked, all deductions, net wages earned, the period for which the employee is paid, the name of the employee, the last 4 digits of the Social Security number, the name and address of the legal entity that is the employer, the applicable hourly rate, the number of hours worked, etc. And beginning July 1st, 2015, you also need, of course, as we mentioned previously, to include the sick leave available. Okay, what else is unique about California? Independent contractors. This is another big issue in California as it is in the rest of the country right now. We have our own rules for determining who's an independent contractor and who's an employee, and we do not in California use the IRS 20-factor test. Why should we make anything easy? California Labor Code Section 3353 defines an independent contractor as a person who renders service for a specified recompense for result of his work only, and not as to the means by which such result is accomplished. And furthermore, the label placed by the parties on the relationship is not dispositive, and subterfuges are not countenanced. And of course, what happens is many employers will call employees independent contractors, even have contracts or employment agreements that say that, when under California law, the employee really is an employee and not an independent contractor. And as the Viola case states, and this is a leading case in California on the independent contractor issue, the courts are going to basically ignore the label. So what's the test? Well, under California law, the test for determining whether a worker is an independent contractor or an employee is whether the principal has the right to direct and control the manner and means by which the work is performed. And what matters under the Viola case from the California Supreme Court decision last year is not how much control the principal exercises, but how much control the principal retains the right to exercise. And in Viola, the California Supreme Court upheld denial of class certification on the basis that there were many variations in how the principal's right to control was exercised. So if you're unclear as to whether the worker or the principal has the right to control, you need to review and analyze a list of secondary factors that serve as evidence of the existence or the non-existence of the right of control. And these include whether the person performing the services is engaged in a distinct occupation or business, what type of occupation it is, the skill required to perform the services, who supplies the instrumentalities, tools, and place of work for the person doing the work, the length of time for which the services are being performed, the method of payment, is it by the time or is it by the job, whether or not the work is a regular business of the principal, and whether or not the parties believe they're creating a relationship of an employer-employee, again, without regard to the label placed. And these are all from the Viola case, which is still good law. So why is all this stuff, classification, independent contractor, meal period, rest period, overtime, why is it all important? Well, we all know, of course, you want to comply with the law. But also, in California, we have what we call the California multiplier effect, where a small wage payment violation, say, for instance, missing a meal period, non-payment of overtime hours, off-the-clock work, can trigger a wide range of penalties under the Labor Code, which far exceed the value of the original amount of unpaid wages. So even a minor wage violation can cost an employer millions of dollars in a class action. So how does this work? Well, first, there are waiting time penalties. The Labor Code, sections 201 and 202, require employers to pay all wages earned within strict time periods from the date of the employee's termination. So under the Labor Code section 203, for every day the payment of final wages is delayed, employees are entitled to 1 day of wages up to a maximum of 30 calendar days. So if you miss an hour or so of overtime or a day or a meal period for a period of time, you're going to owe a waiting time penalty because that money was not paid to the employee on time. There's also wage statement penalties. We went over the wage statement requirements a while ago, but if your wage statement doesn't include overtime because you misclassified the employee, or meal periods were missed, or breaks were not given, you may be subject to wage statement penalties because your wage statement is now incorrect. And the employee gets actual damages, basically the time not paid, but there can be penalties also up to a maximum of $4,000. California Labor Code does not provide civil penalties for these payday requirements. Penalties can be assessed under the California Private Attorney General's Act, and the PAGA, as we call it, provides monetary penalties in the amount of $100 per employee per pay period and $200 for subsequent pay period, including attorney's fees. So this can add up pretty quickly. We also provide in California premium pay for missed meal and rest periods. So 1 hour of wages for each missed break for every day worked, plus, of course, the unpaid wages themselves. So for someone making $10 an hour who misses lunch, you now owe that employee $20. Now, there's a 3-year statute of limitations on all of this, but if an unfair business practice claim is made, that's now going to be expanded to 4 years. But there's 3 years under the Labor Code. So we have here on the next slide just some of the settlements from 2014 and 2015, and you can see Brinker's a target, as you can see, $56.5 million settlement. But you can see that some of these settlements are pretty big, and here's what we spoke about before with the cheerleaders. The Oakland Raiders cheerleaders case, a wage and hour case, settled for $1.25 million. So you just need to be very careful on these issues and avoid getting dragged into a class action, which can cost a lot of money, as you can see. Okay, so what's unique to California on the litigation front? We just spoke about PAGA, the Private Attorney General's Act, which was enacted by 2014 over Governor Schwarzenegger's veto at the time. So the governor did not succeed there. So what is this PAGA? PAGA gives a private citizen the right to pursue fines that would normally only be available to the state of California. And so what happens is that if you collect these fines, these civil penalties, they're split between the California Labor and Workforce Development Agency and the employee, with the agency taking 25% of the penalties and the employee receiving 25%. And importantly, the employee can seek penalties not only for violations that he or she personally suffered, but also for violations of other current or former employees. So we're seeing these PAGA claims raised in virtually every case now brought against California employers on the wage and hour front. Now, these just don't come out of the blue. Prior to filing a PAGA lawsuit, the employee must notify you and the state agency of the violation in an attempt to permit a voluntary early resolution of the alleged violation. And the way this works is that once you get notice, you have 33 days to cure the violation and to notify the employee of the Labor and the Workforce Development Agency of what you've done to cure the violation. And if you don't timely cure the alleged violation, the employee can then file a PAGA claim in state court. If you say you cured the violation, but the employee doesn't believe you, he can notify the agency, which can then take up to 17 days to investigate and then grant you an additional 3 business days to respond. And after this, if the agency determines that the violation has not been cured, the employee can file a PAGA claim. And if the agency files the violation has been cured, but the employee disagreed, the employee has to appeal the agency's decision. And what's important here is not only the civil penalties, but a PAGA claim is a way for the employee to recover attorney's fees and costs. Okay, we talked briefly before about arbitration clauses. California law allegedly favors arbitration agreements, although it's kind of hard to believe with some of the cases that we see here. And under California law, even though we favor arbitration agreements, an affirmative defense to the enforcement of an agreement providing for an arbitration clause is unconscionability. Now, the party resisting arbitration supposedly bears the burden of proving unconscionability, but in practice, it's usually the employer who is defending the arbitration agreement is going to bear the burden of proof. And under California law, and this may change under that Sanchez case, currently there's a substantive and procedural element of unconscionability, and an agreement to arbitrate can only be enforceable in California where both substantive and procedural unconscionability are present. It's not enough that one may exist without the other. So what are these things? Well, procedural unconscionability concerns the manner in which the contract was negotiated and the circumstances of the parties at the time. Procedural unconscionability looks at whether there was oppression arising from the inequality of bargaining power or surprise arising from buried terms in a pretty complex printed form with small type like you see on TV for cars or whatever. But contracts offered in connection with employment are not necessarily procedurally unconscionable, even though they're considered contracts of adhesion. So what's substantive unconscionability? And here's where the Armendariz case comes into play. An arbitration agreement is enforceable under California law if it provides for several factors. The first being, of course, a neutral arbitrator. The second is the arbitrator is required to provide a written decision which is subject to judicial review under the California Code of Civil Procedure, which provides for either vacating arbitration awards or confirming them by the California Superior Court. What's very important, and which can make arbitration very expensive, is that under the Armendariz case, the employer has to pay all costs which are unique to the arbitration as compared to a civil action. In other words, the employer has got to pay the arbitrator's fees, the cost of the arbitration, such as AAA hearing fees, and any other unique arbitration costs. And this can be a lot of money because a lot of arbitrators, particularly in Los Angeles, are charging $10,000 a day. You must also provide adequate discovery. It can be limited, but it has to be adequate so that the employee has some form of discovery. And you have to allow recovery of all statutory remedies. Moving on to the California Unfair Competition Law, we like to call this the unclassed class action. One of my associates was speaking with then California Supreme Court Justice Janice Brown, and she told her, well, Section 17200 is the bane of my existence, and Janice Brown stated mine too. And here are some of the headlines that we've seen in California courts. We see these claims now under the unfair competition law in virtually every single case, including employment cases, both individual claims and class actions. And why do we do that? The plaintiffs love these claims. The law's been on the books since 1932 or so, but we see more and more of these claims in the last 10 years because Section 17200 prohibits unlawful, unfair, or fraudulent acts or practices and is a way for plaintiffs to make claims and to assert claims for things that not necessarily are allowed under other law, where there's no private right of action, for instance. So what's unlawful? Well, something is unlawful under the unfair competition law when the act or practice violates some other law. So essentially 17200 is a borrowing statute. You can show a violation, for instance, of a wage and hour law, of an insurance law, of any type of law, and that gets you into a 17200 claim. Now, I don't know about you if you have kids, but when my kids were young, we prohibited using the F word at the dining room table. Dad, that's unfair. Mom, why can this person do it but I can't? That's not fair. And so we've codified that in California because we've defined an unfair practice as conduct which is not fair. Now, what that is, we don't know. But a business practice can be unfair and violate Section 17200 even if it's not unlawful and even if it's not deceptive. And here's one of the tests that the courts have used to determine whether a business practice is unfair, you look at the impact on the victim, and you balance that against the reasons, the justifications, and the motives of the alleged wrongdoer. And you balance that again against the harm. So this is kind of a nebulous standard. It's kind of like Supreme Court said about obscenity, I know it when I see it. Also, though, California's courts have adopted some of the language from the FTC guidelines with respect to unfair conduct. So a practice can be unfair under the unfair competition law when the practice is immoral, unethical, oppressive, unscrupulous, or substantially injurious to consumers. But there's more here, because we also have a different definition of fraud under the unfair competition law. So what, you may ask, is fraudulent under the unfair competition law? It's fraudulent. A business practice is deemed fraudulent if members of the public are likely to be deceived. It doesn't matter whether there's proof of intent or scienter or reliance or damages, and there's no requirement that anyone actually was deceived or that anyone relied upon the fraudulent practice or sustained any damage, because 17-200 is a strict liability statute. No showing of intent is required, and as you can see here, there's not even a requirement of reliance or actual deception. What's important about the unfair competition law is that all of a sudden, if an unfair competition law is alleged in the complaint, the statute of limitations on a wage and hour claim or on a harassment claim is expanded to 4 years. The courts have held that the UCL, the unfair competition law, is preempted by the FLSA and ERISA. So that's an affirmative defense, as well as a safe harbor provision that this practice is permitted by law. However, the good news about the unfair competition law is compensatory and punitive damages are not available. Remedies are limited to injunctive relief or restitution, which obviously can be the same thing as damages. However, the UCL also permits, when a government agency brings an unfair competition law claim, civil penalties up to $2,500 for each violation. And these remedies are cumulative to other remedies available under other laws. So if you've got a claim that results in damages and a UCL claim, these claims can be added together. And although attorney's fees are not provided under the unfair competition law, the attorney's fees may be sought under a PAGA claim. So 17-200 claims for injunctive relief are not arbitrable under the law, are arbitrable, but claims for restitution are not. 17-500 also provides a false advertising claim prohibiting dissemination of untrue, misleading advertises, but this section actually requires scienter. Okay, moving on to what's also unique about California is the Fair Employment and Housing Act, which is under the auspices of the Department of Fair and Employment and Housing. This is our Anti-Discrimination and Harassment Act. So under FEHA, the protected classes of employees include, well, this could be anyone, but obviously employees, age, genetic information, marital status, medical condition, mental or physical disability, national origin and ancestry, pregnancy, race and color, religion, sex, including gender identity, pregnancy, childbirth, sexual orientation, and military and veteran status. And FEHA importantly protects not only membership in a protected class, but perceived membership in a class. And under FEHA, California, of course, as it likes to do, has its own retaliation provision. Any adverse employment action taken against an employee who opposes FEHA prohibited practices or files a complaint, testifies, or assists or participates in an investigation or proceeding conducted by the DFEH is protected. Now, what's unique to California law is it's unlike under Title VII, which limits maximum damages to $300,000. There is no cap under California law. And an employer may be required to pay actual damages, including back pay and front pay, compensatory damages for pain, suffering, humiliation, and embarrassment, in other words, emotional distress damages, punitive damages, only limited by the the U.S. Supreme Court's State Farm versus Campbell decision, attorney's fees and costs, and even a remedy of conducting training on FEHA. And California, of course, provides its own whistleblower protection. And broad protection for whistleblowers is provided under Labor Code Section 1102.5, and it's illegal in California to prevent an employee from disclosing information to a government or law enforcement agency, disclosing information to a person with authority over the employee, disclosing information to another employee with the authority to investigate, and providing information to or testifying to a government agency. If the employee reasonably believes that the information disclosed is a violation of law or noncompliance with the local, state, or federal rule or regulation. So I think it's important as we close here that you review your employee handbook and policies to make sure they're compliant with California law, make sure your arbitration agreements are up to date, and to make sure you have waiver periods for when an employee wants to miss a meal period. So again, thank you for joining us this morning. If you have any questions about this or any other issue we've raised today, please drop me an email or give me a call. Thanks very much. Bye.